Thank you, Michael. Roy, can you put the first slide up, please? Thank you. The talk draws on this book, which, as Michael said, was published last autumn. The book was the outcome of a project that includes detailed discussion of the policies and practices of 8 major states involved in the arms trade, as well as international and regional regulation. This required securing the participation of experts from around the world and gathering most of them together to discuss issues and compare approaches. This was only made possible by the support of the college, which awarded me a grant to host a workshop in the Barclay Room, which lasted for 2 days. Support I was very pleased to acknowledge in the preface of the book and to repeat here. As the title suggests, for many, but not all states, the arms trade is a law-governed activity. In fact, after I gave a rather different talk on the arms trade to a GTC symposium some years ago, someone said afterwards with great surprise, I didn't realize all these arms sales you read about are legal. The depiction of clandestine sales to warring militias in films like Dogs of War or Blood Diamond highlights the most savage violence made possible by imported arms. And this has shaped, but it's also warped, public understanding of the arms trade. Actually, there exists a dual arms trade. Illegal sales of small arms and light weapons, which until recently have had the most lethal effects. Kofi Annan, about 20 years ago, called them the real weapons of mass destruction, are of minor economic importance to the major arms-producing states. Small arms and light weapons like Kalashnikovs, grenades, and manpads are easy to make and very cheap in comparison to equipment such as fighter and bomber aircraft, their operating systems, and the bombs and missiles they drop, not to mention marine vessels. These items are individually expensive. Some may cost billions and collectively cost tens of billions of dollars and employ hundreds of thousands of people. Their importance to the economy as a whole of any one nation is too often exaggerated, but the political power of those engaged in their manufacture cannot be. These weapons are known as conventional arms. This category excludes nuclear weapons and so-called pariah weapons, chemical, biological weapons, landmines, blinding lasers, and the like, whose export is generally prohibited by international agreement. Take the slide down, please, Roy. A basic and contentious question about the arms trade concerns its justification. Some argue for its abolition. My own view is that some commerce in arms is not only essential, but even desirable. It is essential because all states have the right of self-defense, which is a fundamental principle of international law, and require the means to do so. It is desirable in the specific and limited sense that for poor and lower income states, which lack the technology and the workforce possessing the specific skills required for advanced arms manufacture, developing an indigenous arms industry would be an economic absurdity, diverting scarce resources away from investment in human capital, infrastructure, and social necessities. It makes developmental sense to import necessary materiel. But to argue that some arms sales are necessary absolutely does not entail supporting the present levels of armaments throughout the world, quantities which are being bloated by a combination of national self-aggrandizement, corruption, and the determination of regimes in power to control their populations. I would like now to present some basic facts about the arms trade, focusing on the key national players involved. In 2019, the world's 25 largest companies sold $361 billion $361 billion worth of arms and military services. By definition, this omits literally thousands of smaller companies, mostly providing components, technology, or making small arms and light weapons. The figure is also limited to legal sales, so the total trade is well over 400 billion, could be approaching 500 billion US, and the trend is upward. In that past year, 2019, was an increase of 8.5% over the previous year. The top 5 companies are all based in the USA. The list also includes 4 Chinese firms, and for the first time, 1 from the Mideast, based in the United Arab Emirates. Sales are heavily concentrated in zones of instability like the Middle East, North Africa, Sub-Saharan African countries, and parts of Southeast Asia. This represents a reverse and indeed perverse development aid, whereby countries of the global south, some of them notably poor, are sustaining important industries in the north and in China. Now, over 80% of all exports originate in the USA, the EU states considered collectively, and Russia in that order. Far and away the largest exporter is the USA, and the largest in Europe within the EU states is France. Now, these data are compiled by the Stockholm International Peace Research Institute, which is far and away the most reliable source of information in this area, as does the data in the next slide. Can you put up slide 2, please, Roy? Thank you. Now, on even a casual look at this very useful chart, which I hope is clear, certain trends stand out. One is the large increase over this last 5 years in the USA's share of world exports, which began well before Trump took office. Another is the remarkable increase in share enjoyed by France, the rogue state of Europe, which has enthusiastically sold weapons to virtually all comers. A portent for the future is the sharp rise, admittedly from small beginnings, in the total sales of South Korea, Israel, and Turkey. And the fourth feature is the significant decline in sales by Russia, Ukraine, and also the UK, despite claims of the present government. The UK nonetheless remains the world's 6th largest arms seller. Now, when one looks at what SIPRI calls the clients, which is the right half of the chart, purchasers, a pattern emerges of certain states being closely connected to specific other states as suppliers. In some cases, these ties reflect political relationships, in others, economic motives predominate, but the two are always intertwined. One normally thinks of the seller using the availability of its weapons as a means of influence over the buyer, and that has indeed happened. But in some instances, the reverse may be true, and the clearest case of this is the UK. Looking at this slide, you'll see that the first of the UK's main clients took 41% of its total exports. I hope you can see that right there. Which makes the UK more dependent on exports to a single state than any of the other top 6 exporters, and that purchaser is Saudi Arabia. This has led to UK policy in a range of important international matters becoming captive to the Saudi state and its wishes. That dependency has existed for decades, but its extent and moral consequences were largely hidden until the Saudi bombing and blockade of Yemen thrust it into prominence in 2015. I will return to the issue of Saudi arms sales, but this unique dependency is the key to understanding the intransigent continuance of UK exports, even as the Biden administration recently announced a suspension of exports to weapons that the Saudis could use in offensive operations, as several European states had previously done. This dependency is a key fact and one that is seldom mentioned and largely barely understood in this country. You can take this slide down, Roy, please, now. Thank you. The arms trade has, as it were, come under fire for a range of reasons. One, making possible the commission of atrocities and human rights violations by governments against their own populations, making possible violation of international humanitarian law, which I will call IHL, which is the laws of war. Thirdly, diverting resources of less developed countries away from investment in health, education, and housing into purchase of unnecessary weapons. For the motivation for this diversion being located in corruption, money or other benefits received by politicians and officials in the purchasing countries for agreeing to buy weaponry or to pay inflated prices for it. Persuasive arguments have been made that of all forms of commerce, the arms trade is enmeshed in the greatest amount of corruption. 5, encouraging regional instability and aggressive behavior by recipients. 6, the absence of adequate controls on the behavior of purchasers has enabled a diversion of weapons to non-state terrorist organizations. And finally, and in my view, the least adequately appreciated, the arms trade has had a devastating blowback effect. It has badly weakened the ability of exporting states like the UK to maintain honest, open, and constitutionally accountable government. Most of these evils have intermittently been recognized by Western governments, which have enacted legislation designed to curb the discretion of their executive branches in various ways. These laws purport to restrict excuse me, I have a bad cold, report to restrict sales or gifts for which there is some likelihood of producing certain specified undesirable consequences. Measuring that likelihood, the so-called risk assessment, is highly controversial and in practical terms, perhaps the most important element in export control decisions. Now, these laws have been drawn up by governments of Western exporting states, generally in response to political pressure arising from scandals of various kinds. There has been international effort as well, resulting in the Arms Trade Treaty, which came into force in 2014, but its minimal impact thus far means I shall speak today only of domestic export controls. Some purchasing states led by India, one of the many which are former colonies or protectorates of European exporters, sometimes claim that they are once again being subject to a form of imperial domination. This claim would ring less hollow if their rulers were not so often involved in the corruption or repression that surround the sale and use of weapons. However, this imbalance of power has led and will continue to lead some purchasers to develop their own arms industries. Some have been more successful than others, China most clearly, hence the 4 largest of the 25 largest companies being based in China. But the presence of a UAE company among that list is a straw in the wind. India, too, as described in one chapter of this book, is aiming to go in the same direction. Insofar as the pressure for more stringent export controls is exerted in hope of curbing injustices and abuse, the opportunity to do so may have an increasingly restricted window with respect to some major states of the global south. Now, to explore the legislation, and given the limited time available, I want to concentrate on 2 of the 8 criteria that EU states have agreed to adhere to before approving sales. EU states for the moment includes the UK, which was a prime mover in drafting these criteria more than 20 years ago and enacted them into UK domestic law. This leaves them untouched by Brexit, at least for the present. Can you put up slide 3A, please, Roy? Now, this criterion 1, the language here is far more forceful than that found in any of the other criteria. It leaves no room for, quote, balancing, for risk assessment, or any other analysis that would admit countervailing considerations into the judgment. This criterion gives overwhelming importance to international and regional non-proliferation agreements and sanctions regimes. It is closely linked to the imperative of preventing diversion, weapons landing in the hands of governments or forces other than the ostensible recipient, often as a result of successful evasion of an embargo. The directness of the language here, the absence of any risk assessment requirement, is a telling measure of the importance governments accord to non-proliferation agreements and sanctions implementation. The brute fact is that Western exporting states have a degree of self-interest in securing the success of the instruments detailed in this criterion that exceeds by far the stake they have in preventing violence against unknown citizens living far away. Now, the comparative language makes this clear. Can I have the next slide, please, Roy, slide 3B? Thank you. Here, the determining test, as you can see from the very first line, is clear risk, a concept nowhere defined and which is predictably received wildly varying interpretation and application by different states, especially where the political or economic relationship with the would-be purchaser is close. Secrecy aids discriminatory favoritism, since much of the information relevant to the assessment will consist of details of military capabilities and intentions, and judgments about the leadership of the state in question that is zealously excluded from any form of public scrutiny, including legal proceedings. And quite apart from discrimination, how clear the risk must be before a sale is prohibited remains so open-ended that it inevitably remains in the eye of the beholder. Now, internal repression, which is unfortunately this thing is blocked at the moment, but which is again the last line in paragraph A, is a term specifically created for this legal instrument. It is otherwise unknown to international law and, so far as I know, to any national law. It is clearly designed to be wide-ranging, and as you can see from the definition in paragraph B, it goes well beyond violence and extrajudicial punishment of dissenters, for the international human rights instruments referred to include matters like freedom of expression and non-discrimination on grounds of ethnicity. The objection to sales to dictatorships using imported weapons to suppress opposition to remain in power was the single most influential force driving forward arms sales restrictions in the 2 decades following the end of the Cold War. And the key legal instruments were designed primarily with this end in mind. It caused great controversy because it runs contrary to the international law principle of sovereign equality of states, which for a long time dictated total non-interference in purely domestic matters. For a time, it became mixed up in debates about so-called humanitarian intervention and responsibility to protect. These latter controversies have faded, at least temporarily, but the fundamental question in principle remains. Withholding weapons from a state because of its treatment of those within its jurisdiction is undeniably an intrusion on sovereignty and leaves states advocating it open to allegations of hypocrisy on 2 grounds: human rights violations within their own borders and uneven or dishonest application, the discrimination point I mentioned earlier. Now, having a look at paragraph C here, serious violations of IHL, the very last few words. This issue was not really on anyone's radar until the past decade. Before then, there was a widespread belief in the USA and Europe that wars between states were a thing of the past, and that the problems of international order were primarily those of failed states and bad internal governance. Hence, IHL violations were not even included in the original form of this criterion, were only added 10 years later. IHL, which governs the conduct of warfare, covers both the way states at war treat their armed opponents, but also, and this is one of the great advances of the 20th century, the treatment of civilians and civilian institutions such as hospitals and schools. Serious violations, the phrase used here, most definitely include attacks on civilians and civilian targets. The UAE and Saudi bombing of Yemen, which had first occurred more than a decade ago but greatly intensified in 2015, thrust this issue to the fore for the first time. This kind of blindsided the UK, particularly because there had long been a certain cynicism within parts of the UK government about selling weapons to places like Saudi and other Middle Eastern oil kingdoms. The expectation was that these weapons would never be used, that they had been bought for prestige purposes by countries with more money than sense, and that we could profit from their profligacy. You take down the slide, please, Roy. Thank you. As Yemen's humanitarian catastrophe unfolded and most European governments continued to supply weapons, campaigners turned, in most countries for the first time, to seek redress in the courts. Actions have been pursued in the Netherlands, France, and Italy, mostly without success. Political pressure has had some success, notably in Germany, Sweden, Wallonia, which has a separate arms industry, and most recently in Italy. But the one country in which a legal victory of sorts was achieved is England. Discussion of this litigation could occupy a seminar in itself, but the salient point today is that the judgment of the Court of Appeal shows simultaneously the value, both the value, but also the practical limits of the strategy of litigation to achieve legal compliance. Very briefly, an NGO known as CAAT, Campaign Against the Arms Trade, alleged that the UK government failed to apply criterion 2C correctly. The court firmly refused to consider whether there was, in fact, a clear risk of serious IHL violations, and equally firmly ruled out any judicial role for determination of the merits of license approvals. What remained for its consideration was process, a very characteristically judicial approach. Did the government properly examine the relevant evidence which any rational decision maker should have considered before coming to a conclusion? This is a well-settled principle of administrative law, of judicial review. And the court concluded that the government failed this test. The legal result was that the matter was remitted to the government to review its assessment procedures. Partly due to a strategic decision taken by the litigants, the existing licenses were allowed to remain in force. The practical result was that after several months, through a process undertaken entirely without public participation or consultation, the government concluded that with only minor tweaks, it could lawfully continue to follow its existing decision-making procedure. CAAT announced that it would once again seek judicial review, so watch this space. But it will take months, if not years, before we get any kind of judicial result. For those seeking to ensure that the government complies with the law, the decision had the benefit of establishing that official discretion must indeed operate within the limits of the criteria, and that ministers and civil servants must be able to justify their decisions in light of them. However, the vast scope of that discretion in anything touching on foreign relations was acknowledged by the court. So the likelihood of judicial intervention on any matter of substance remains vanishingly small. Could you put up the final slide, please, Roy? Thank you. One point not put before the court would have portrayed in sharp relief how the flexibility and ambiguity inherent, I stress that, inherent in language like clear risk, which is designed to accord wide discretion to decision makers, enables political considerations to alter the pattern of decision without altering the law. This can be demonstrated by the record of decisions involving criterion 2 taken by UK successive governments. Now, this slide took me quite a long time to assemble. It required combing through a decade of annual reports and then calculating the frequency of use of each criterion. This data has some limitations, but they do not detract from the main conclusion, which is the close connection between political party or parties in office and the use of the criterion. Most notably, the decline once the Conservatives became the sole governing party in mid-2015, and that's this column here about coalition / conservative after 2015. That decline is stark. Within 2 years, use of criterion 2 declined by 80%. You can see it goes from 17.0 down to 3.6 and then 3.7 and remained close to that level. This criterion is the most politically sensitive as it addresses respect for human rights and IHL violations and involves purchasing states which in total almost certainly comprise more than 50% of all total UK arms sales. Saudi Arabia is the most prominent offender, but it's hardly the only one. And the criterion has in recent years become a matter of partisan disagreement as well. The data firmly established the paramount importance of who is taking the decision, and under current practice, this political influence is inescapable. To conclude this talk, I want to offer a brief and therefore unavoidably inadequate set of suggestions for how such an escape might possibly be engineered. Ultimately, I suggest this is a matter of institutional design, and in constitutional terms, what must be curbed is the overwhelming dominance of the executive. The UK does have a parliamentary oversight body, but its effectiveness is heavily dependent on individual MPs choosing to be actively involved. And for the past 5 years, have seen a sharp decline in its ambition and achievements. In my view, what is required is the creation of a body independent of government in the same way that the Bank of England or the Parole Board are independent, that would be empowered to consider license approvals involving those countries which have either featured on the Foreign Commonwealth Office annually produced list of countries of human rights concern, or which a small but significant percentage of MPs petition to be considered. Its membership would be full-time, thus excluding MPs, and would be drawn from a wide range of professions and areas of expertise. Whilst there are good arguments that it should have the power to decide such cases, the political reality is probably that all governments would want to have the final determination. In that case, a government that chose to overrule this agency's decision would be required to give detailed public reasons for its overruling. And if it relied on classified information in reaching its conclusion, it should summarize that material sufficiently clearly to indicate its relevance and importance. This is a very brief sketch indeed, and I'm happy to go into it further if anyone wishes. And thank you very much for your attention. I hope these charts have made things clear.
Great, thank you for that, Laurence. I'm wondering if you would take just a couple of quick questions. We are running over a little bit, but Paul Brankin asks, he says, I noticed in your slide of arms exporters that 46% of India's arms go to Myanmar. Does this mean that India is in practice a key supporter of the Myanmar army dictatorship?
Simple answer to that is yes. Between Myanmar and China, you've got most of the, between India and China, sorry, you've got most of the arms that the military government gets, and that is a fair conclusion.
Right, good. And from Becca, are there any measures that secure against the risk of the client selling weapons onto third states?
That's what the diversion thing that I somewhat inadequately sketched is about. There are supposed to be end use and end user controls. The UK for a long time operated a system of when in doubt, don't let it out, but then went on to say when it's gone, it's gone. This is proving increasingly questionable. The US has run something called Blue Lantern and Golden Sentry for a long time, which actually tracks what is done with the weapons it sells. In the last 4 or 5 years, Germany and Switzerland have gone down the same route. And there is some pressure that the UK should go the same way. It's very hard to know. Between Brexit and COVID, the UK government has been completely absorbed in everything else for the last 3 or 4 years. And my understanding of the people now in the FCO is that those on top have no interest in doing so. But there was an interest. It may come back. But clearly that needs to be done.